morning and welcome to this module. With this module, we are introducing the concept of ethics in digital communication. In this module and some following modules, we shall also highlight the characteristics and impact of ethical and non ethical behavior in the context of digital communication. Let us begin by discussing the concept of digital ethics. It is a rapidly growing field of inquiry that has been gaining increased attention from academics and stakeholders across various fields, as technology plays an increasingly important role in our everyday life. This module will explore the concept of digital ethics, which refers to the moral principles and guidelines governing technology and digital platforms. Digital ethics is concerned with how technology is used and what are the potential consequences of its use. It includes considering certain factors, for example, the potential violations of human rights, the protection of personal information and data, which is precious to all of us, and the impact of technology on vulnerable communities as well as vulnerable environments. The origins of digital ethics can be traced back to the evolution of the internet as the underlying framework enabling the exchange of information and communication. The internet quickly made groundbreaking advances during the early 1990s, and it culminated in the formation of the World Wide Web in 1995. As the internet continued to develop and became more connected, it started capturing vast amount of personal data. Thus, the ethical considerations associated with its use broadened exponentially. Discussion on ethical issues have captured the attention of scholars from early iterations of the web to present day. Discourse on digital ethics originated from the increasing awareness regarding ethics in academics and administrative practices. The formation of the World Wide Web had revolutionized access to the digital, but simultaneously it also raised a wide array of ethical questions regarding data privacy, censorship, and the terms of digital contracts. Fontaine and Hunter in 1998 had offered a collection of essays on ethical issues titled Foregrounding Ethical Awareness in Composition and English Studies. Harrington, in a review essay in 1999, had observed that the current discussions vary considerably in approach as well as how ethics relates to what we do as teachers and scholars. As during this time, the web was emerging as a force for communication, civic discourse, public activity, and education. These words almost sound prophetic now. The emergence of the web led scholars to redefine and re theorize the concept of rhetorical ethics for online rhetoric and later a digital ethic for new online environments. Privacy online was also identified early as an ethical issue of rhetorical import by Gurak in Persuasion and Privacy in Cyberspace, published in 1999. Digital copyright and authorship were also widely examined as contentious legal issues rife with ethical implications. Thus, new environments for communication presented new ethical issues for consideration within digital ecosystems and among ecologies. Harrington's essays were relevant to teaching and administrating composition classes and program when the field was reportedly taking an ethical turn. Harrington had located its roots in the connections developing at the time between administrative practices and pedagogical choices to the social, cultural, and political milieu developing in contemporary times. The development of digital ethics, moreover, stemmed from the commercialization of digital technologies. And as we know, digital technology has changed how we live, work, manage our money, travel, and communicate. So, digital technologies are a powerful tool, and digital technology related products are now sold almost universally on every street corner. Prices have also become competitive due to cheaper sourcing techniques and greater utilization of global manufacturing capabilities. However, digital technology also carries significant risks if misused or commercialized in an irresponsible manner. As commercial applications of digital technology have become commonplace, companies have faced a slew of ethical considerations regarding the security and privacy of customers' data. Measures to prevent cybercrime and the use of algorithms to profile customers. Companies gather data on consumers through a practice known as data mining, which uses algorithms designed to target potential buyers based on past purchases or click paths within websites. This strategy gives businesses access to vast amounts of data, which they can use for targeted marketing campaigns. It also allows them to know about products that may not have been previously advertised using traditional methods such as television commercials, radio spots, etc. Also, technology cannot overlook massive financial inequality, which leads to data colonization and data consumerism. The term data colonialism was coined by professors Nick Caldry and Ulysses Magis. It refers to the trend of dominant global technology companies exerting significant control over the cultural, economic, and political domains of less powerful nations. This term also reminds us what Lyotard has suggested in this context. As technology use and manipulation becomes increasingly pervasive, the use of and implications for digital ethics also become increasingly urgent. I would just quote a particular argument from Lyotard's essay on the postmodern condition, a report on knowledge, published in 1979. And I quote, in the discourse of today's financial backers of research, the only credible goal is power. Scientists, technicians, and instruments are purchased not to find truth, but to augment power. This argument is relevant in the field of data colonization also. Such arguments enhance the relevance of digital ethics in the contemporary age. So, what exactly makes it relevant to us now? Digital ethics is shaped by the technological revolution, and it has transformed over the past 2 decades. It can also extend beyond physical and geographical limitations, impacting our lives globally. With increasing reliance on digital technologies, the influence of digital ethics has also grown exponentially. Encompassing legal regulations, privacy, and data protection, digital ethics informs our ethical conduct in the digital realm. Furthermore, it is necessary to promote responsible usage of technology and establish the necessary frameworks for ethical interactions. The diagram on the right hand top side shows the relationship between digital ethics, digital regulation, and digital governance. It entails a responsible usage, talks about the requirement of a framework for ethical consideration, also underscores the need for guiding interactions with technology and fostering responsible practices. And therefore, we can say that digital ethics is an essential pillar in our digital online communication also. One example of measures taken to uphold digital ethics is the General Data Protection Regulation or the GDPR rules, which was developed by European Union in 2018. It can be seen as a strong set of data protection rules which regulates how organizations can access information about them and places limits on what organizations can do with the personal data of the people. It strengthens the defense of personal data online. Let us look at a video for more information on these regulations.
The General Data Protection Regulation, or GDPR as you've likely heard it called. It goes into effect on May 25th and it could affect you, no matter where you are or where you live. How? Let's answer some questions. So, what is GDPR? It tightens Europe's already strict laws about what companies can do with people's data. It gives you more control over how your data is collected and used, and forces companies to justify everything that they do with it. While GDPR is European Union legislation, it has a huge effect on businesses outside the EU, including the US. Why was GDPR introduced? Because the old laws were written before smartphones started collecting massive amounts of sensitive information for companies like Google and Facebook. GDPR gives organizations guidelines on what they can and can't do with personal data. It also makes them give users more clarity over the kind of data being used and how companies will use it. What is considered personal data under GDPR? Any data that can identify you. That's your name, phone number, or username, but the law also includes things like your IP address or location data. Even tighter rules apply for sensitive information such as sexual orientation, health data, and political opinions. How will it affect you? One way is that you will often have to opt in to letting a company use your data. This means fewer pre-ticked boxes, and firms are compelled to use clear and simple language. Do people have the right to be forgotten? Yes, people can request to have their data deleted. Personal data also needs to be transferable via a common file type. However, the right to be forgotten is not absolute, and certain conditions apply. Why is GDPR a concern for non-EU countries? Because many businesses collect or use EU residents' data. They also use companies based in the EU for services and processing data. What happens if a firm doesn't comply with GDPR? The penalty could be up to 20 million euros or 4% of annual turnover, whichever is larger.
After this brief introduction about the concept of the GDPR, let us now expand upon it in somewhat detail. One of the most important things GDPR talks about is the idea of the consent. The subject's consent is necessary for processing data under the regulations of GDPR. GDPR also extends beyond the EU, and therefore it applies to all international businesses working within or outside EU, but who might be handling the data of European citizens. It also puts emphasis on enhanced data security and privacy protection in order to safeguard the online available data of different individuals. It also calls for a certain transparency and accountability, and companies are mandated to be more transparent and accountable in their handling, storage, and management of personal data under the GDPR. As we have already commented, GDPR applies to any organization worldwide that handles personal data of European residents, ensuring that the data is protected and there is a compliance of these regulations regardless of the physical location of any organization or company. Thus, it has a global applicability. It is applicable not only to the EU companies, but it is also applicable equally to the non-EU companies. It also requires compliance outside the EU, and companies who are outside the EU must adhere to GDPR regulations when collecting, processing, or storing personal data of individuals who are a part of the EU. It also insists on a format neutrality. They apply to all types of personal data, irrespective of the format of the storage or the medium. We can say that one of the core tenets of the GDPR is the protection of the rights of data subjects or the rights of the European citizens whose personal data is being collected, processed, and stored by different companies and organizations. It can also be mentioned at this point that GDPR outlines 8 rights for data subjects. They are the right to access their data, right to be forgotten, right to object to processing, right to rectification, right to be informed, right to restrict processing, right to data portability, and also the right to withdraw consent. By adhering to the regulations prescribed by the GDPR, companies are able to ensure that the personal data of their customers is secure and remains protected. Indian legal system has also taken cognizance of the threats Indian citizens face in the new digital world. Data protection in India is regulated by the Digital Personal Data Protection Act 2023. The act sets out norms for data processing digitally for firms, creates an adjunctory mechanism for resolving disputes, and also provides for the creation of the Data Protection Board of India. Digital Personal Data Protection Act 2023 ensures that firms handling user data must safeguard the personal data even when it is stored with third party data processors. Companies are also required to promptly notify both the Data Protection Board as well as users in case of a data breach. One of the major provisions of the Act is that the processing of children's data as well as the data of especially able individuals with guardians must have consent from their respective guardians. At the same time, companies are obligated to appoint a data protection officer and furnish this information to users. It is a comprehensive act which incorporates all contemporary threats to data protection and addresses them efficiently. Let us also briefly look at the provisions which existed before it and which have maturely been incorporated in the new act. The first act we can refer to is the IT Act Amendment 2000, which includes Section 43A, mandating truthfulness in collecting personal information and ensuring adequate security measures. Another law which can be referred to here is the Indian Contract Law 1872, which applied universally to all industries and governs contracts involving ICT applications, including data processing and protection agreements. The combination of the IT Act amendment and Indian contract law provided a robust legal framework for data privacy and protection in India. Furthermore, in February 2021, the Indian government introduced a set of new internet rules known as the Intermediary Guidelines and Digital Media Ethics Code. India also has a strong framework for social media regulation. There are Indian intermediary guidelines which were introduced to regulate social media platforms and digital media in the country. The Digital Media Ethics Code sets standards for digital media platforms to follow, promoting responsibility and ethical content practices. The guidelines related with social media regulations specifically address social media platforms outlining their obligations in terms of content moderation, user privacy, and handling of complaints. These guidelines highlight certain requirements that social media sites need to maintain in order to operate within the country. Let us look at some of these requirements. Rules mandate platforms to appoint a resident grievance officer who should be available 24/7 for handling any type of complaints by the users. They also require social media sites to implement proactive monitoring systems to swiftly identify and remove violations such as pornographic material within 36 hours. The guidelines aim to strike a balance between freedom of expression and accountability, ensuring a safer and more responsible social media environment in India. As emerging technologies continue to shape our world, they bring along unique ethical challenges. In this section, we will explore now the ethical considerations presented by the Internet of Things, virtual reality and augmented reality, biometric data usage, and autonomous vehicles. Let us first look at Internet of Things or IoT and privacy concerns it raises. Ethical challenges arise from the collection and sharing of personal data through interconnected devices. Balancing the benefits of IoT with individuals' right to privacy raises ethical questions about consent and data security. If we look at the ethical considerations in the context of virtual as well as augmented reality, we find that these have potential impact on users' well being and mental health. Addressing issues like addiction, distortion of reality, and the blurring of ethical boundaries in virtual environments. Apart from these, ethical discussions on the usage of biometric data and autonomous vehicles also pose a challenge. Collection and use of biometric data, such as fingerprints, facial recognition, etc., raise concern about privacy, consent, and potential misuse. Ethical discussions are necessary to establish boundaries and safeguards to protect individuals' biometric information. Similarly, decisions made by self driving cars that involve potential harm to passengers, pedestrians, or property pose complex ethical dilemmas. Determining responsibility, accountability, and establishing ethical guidelines for autonomous vehicles is also crucial for public safety and social trust. We will now examine a case study which provides insights into the complex ethical landscape surrounding digital technologies. The case study revolves around the Uber Grey Ball program. This controversial software was designed to identify and evade regulators, allowing Uber drivers to operate in regions where the service was restricted or banned. Let us look at a video now.
This about another potential scandal regarding Uber.
The New York Times reporting Uber has utilized a program for several years to deceive law enforcement officials in cities where the ride-sharing service was outlawed. Minutes ago, Uber sent CNBC this statement. It says, "This program denies ride requests to fraudulent users who are violating our terms of service, whether that's people aiming to physically harm drivers, competitors looking to disrupt our operations, or opponents who collude with officials on secret stings meant to entrap drivers." Joining us now is the reporter of this story, Mike Isaac of the New York Times. Welcome, sir.
Hey, thanks for having me.
So in the Uber, let's back up for a second so people know what we're talking about. This is a program called Grey Ball, which in the description that you have in the story here makes it so that if I'm a cop in a city where Uber's not allowed, in Portland is your example here, I believe, and I tried to hail Uber, at least as of a couple of years ago, I would be greyballed because they knew I was a cop. I would get ghost cars on my app that weren't real ones. Is that right?
Yeah, so essentially they set up the program in 2014, 2015, when a lot of the cities that now Uber's legal in didn't really have a framework for UberX, their low-cost program. So code enforcement officers and in some cases law enforcement officers would set up sting operations in order to catch drivers operating what the city would say illegally. Uber would contend that they were operating within the bounds of the law. and essentially tag them or grayball them and be able to evade them afterwards. You know, whether that was sending them a fake version of the app or blocking them entirely,
Right.
or just yeah. So it was pretty crafty.
Okay, so let's revisit the statement from Uber where they admit that they were trying to avoid opponents who collude with officials on secret stings meant to entrap drivers. I mean, they admit that that's what this is all about. I guess it comes down to the issue of whether they're operating illegally in cities where they have been prohibited from operating, right?
Yeah, I think Uber's point here is that they used these tactics for a number of different purposes, and my sources, confirm this too. There are countries in which they operate now, in which drivers are under attack from taxi cab companies or other people who don't want Uber there, and so Uber would use some of these tools to obfuscate their location and keep the drivers safe, and that's totally fair. What I found is that this other sort of branch of how they used grayballing was to evade code and law enforcement, and that was something they did systematically and printed up a playbook and distributed it to general managers in dozens of cities all over the world.
So this was not just an incident isolated to Portland and a handful of officers they were aware of. You're saying if I was a cop or a code enforcer in one of many cities, maybe Las Vegas, where Uber wasn't allowed, most likely if I tried to use this, is it the case maybe even personally? Would the app basically just not work for me?
So if they ended up grayballing you, the thing is they didn't want to outright ban code enforcement officers or police officers because they didn't learn anything else if they banned you from using the service. So keeping you in, seeing how many times you open the app and what devices you were using to access the app actually helped Uber learn more about code enforcement officers' tactics, or Lyft and their competitors' tactics, or taxi cab companies and their tactics. So they actually learn more from keeping you on the app.
All right, so let's take it to the next step then, Mike. What next? I mean, are we likely to hear from prosecutors in various cities willing to prosecute them for the use of this app, this device?
It's hard. Yeah, it's really hard to tell just because this happened 2 years ago. They still say that they're using it mostly outside of the country to protect driver safety. But I talked to a lawyer when I was reporting this out, and there are questions of whether they were obstructing justice in order to sort of escape code enforcement officers or not, or if they were breaking any other potential laws, federal laws versus state laws. So it's really a matter of whether prosecutors in these states or at a federal level want to pursue it.
Hey there, thanks for checking out CNBC on YouTube. Be sure to subscribe to stay up to date on all of the day's biggest stories. You can also click on any of the videos around me to watch the latest from CNBC. Thanks for watching.
The aftermath of the Uber Greyball controversy had several notable impacts and outcomes. Uber faced intensified scrutiny and tighter regulations globally due to the Greyball controversy, urging authorities to address ethical and regulatory challenges posed by emerging technologies. Uber also had to implement measures to rebuild trust, including policy revisions, enhanced transparency, and stronger compliance mechanisms to regain the confidence of users and also those of the regulatory bodies. This controversy also had serious legal implications that prompted a viral discussion on the importance of ethics in the automobile industry. In the context of Uber only, we find that it had to face legal consequences, which included fines as well as some other types of legal actions in jurisdictions where the deceptive practices of the Greyball program were exposed. But it also posed certain challenges to the industry as a whole. This controversy had sparked discussions on ethics and fair practices within the ride-hailing industry, leading stakeholders to prioritize responsible corporate behavior, operational transparency, and compliance with regulations, encouraging the industry to adopt higher and more transparent ethical standards. Overall, the aftermath of the Uber Greyball controversy resulted in an increased awareness of the ethical challenges inherent in emerging technologies. Overall, the aftermath of the Uber Greyball controversy resulted in an increased awareness of the ethical challenges inherent in emerging technologies and the importance of ethical conduct and compliance for companies operating in such spaces. It also served as a lesson for the industry and regulators alike, highlighting the significance of promoting an ethical and accountable business environment. As digital technologies continue to shape various aspects of our lives, from communication and commerce to healthcare and governance, it is crucial to nurture interdisciplinary collaborations to advance digital ethics. It is important that diverse perspectives from technology, philosophy, law, sociology, and psychology contribute to a holistic understanding of ethical implications in the context of emerging technologies. Multiple viewpoints would enable a comprehensive approach to address such ethical dilemmas which are a consequence of technological advancements. Legal experts should identify gaps in laws and regulations, proposing reforms to ensure ethical practices as well as quick compliance in the digital space. Interdisciplinary collaborations pave the way for enhancing ethical guidelines and best practices in the digital realm. Building upon the insights gained from diverse perspectives, the focus now shifts to leveraging this knowledge to strengthen ethical guidelines in the ever evolving digital landscape. Enhancing ethical guidelines suggests that there should be dialogue and knowledge exchange. There should be an identification of the ethical risk, and there should also be a nuanced understanding of the issues at stake. As we know, collaborations foster dialogue and enhance the development of ethical guidelines, frameworks, and best practices needed in the world today. The combined expertise also allows researchers as well as practitioners to identify what are the potential ethical risks associated with emerging technologies. At the same time, interdisciplinary, rather multidisciplinary efforts would promote a holistic as well as a nuanced understanding of digital ethics, which would further facilitate effective responses to emerging ethical challenges, which may also involve socio-cultural differences. This collaborative approach is essential to navigate the complex interplay between technological advancements and ethical responsibilities. In conclusion, digital ethics plays a vital role in shaping our interactions and decision making in the digital age. As technology continues to advance at a rapid pace, it is crucial to recognize the ethical challenges and implications that are arising now. So, what are certain steps which might be taken for an ethical use of technology? They would involve an understanding of the ethical considerations associated with emerging technologies, promoting interdisciplinary collaborations, enhancing ethical guidelines, and empowering ethical education. Embracing digital ethics is not only an ethical imperative but also a strategic necessity to build a sustainable and inclusive digital society. In the next module, we will take a look at the concept of ethical behavior, its fundamentals, and how they impact our day to day lives now. Thank you.